Welcome back to this course on copyright and related rights law. This week we are discussing the concept of originality and how this concept applies as a requirement towards satisfaction of subsistence of copyright in relation to subject matters. In the previous discussion, we considered how original and originality can be split in two dimensions. The first dimension being a simple question of whether a given expression has been copied from another expression or not. And if it has not been copied, then it is original. In this session, we are going to discuss a second dimension, which is a question of should there be a threshold of creativity and additional consideration beyond the first dimension of whether there is any copying or not, or in other words, there is independence of creation. Let us start with University of London Press case once again. In this case, I must stress again for clarity that in the first layer, an objective assessment is conducted wherein if an expression fits the requirement of a subject matter, it is categorized, and then a question of whether it is original or not is conducted. Original, according to the court, is simply independence of creation, that it must not be copied. But the court also highlighted that the term original does not mean original in the sense of inventive thought. In the sense, what the court also highlighted is that copyright acts are not concerned with the originality of ideas, rather with the expression of thought. In this second dimension, we are looking at in what manner should we be considering expressions of thought as copyrightable as distinguished from inventive thought. In fact, in making such a distinction, the court seems to be suggesting that there is some level of creativity which is satisfied for inventive thought and which is not required for copyrightable expression. What is that level? This is what we are looking to focus on in today's session. When we talk about levels, scientific temperament tells us some kind of an objective assessment must also be possible at this point. That is, if inventive thought is different from originality in terms of copyrightable expression, then it should be possible to objectively identify these levels. Because only then can we say that one is copyrightable and one is patentable. But in terms of what the subject matter can also include is functionality. Therefore, in terms of what this level is looking to highlight is merely a distinction of creative input and not in terms of so much as the subject matter itself. In which case, isn't this in some way a subjective analysis which should be a case-to-case consideration? Let us consider the requirement of novelty in patent law. In our earlier discussions, we have made a distinction between what is copyrightable and what is patentable. You would recall in Baker versus Selden when we discussed how the US Supreme Court made a distinction between idea and expression. An example that the court referred to was where a doctor wrote about a particular medicinal formulation and its effect on the patient. The medicine itself cannot be prevented from unauthorized use if a book has been written on it. Rather, there must be a patent that is sought and registered for the medicine itself. The functional consideration is obvious here, but in terms of the level of creative input that is required for patent to be granted is a level of novelty and inventive step, which we can clearly see novelty and inventive step and this idea of an inventive thought. Consider this example. You can see a simple example of a claim. What is a claim? When an inventor files an application for grant of patent, in his patent application, he provides certain claims. These claims provide a boundary of what he intends to cover as part of the patentable invention. Say, for example, the claim reads like this. It says, I claim a tool comprising of Part A, Part B, and Part C, which connects Part A and Part B. You can see from this claim that the inventor is claiming a patent over a mechanical device in which there are specific components which interact with each other in a particular way. Where a new part is added by another person, where now the claim reads, I claim a tool comprising of Part D, Part A, Part B, and Part C, which connects Part A and Part B. You can see that from this earlier claim, there is now a new ingredient which has been added. Novelty and novelty analysis must be made by comparing elements in the prior art with that of the invention, element by element. It would not be possible for there to be some kind of a mosaicing effort to say that this particular claim is not novel. What does that mean? If part D is present in the claim of some other inventor's claim, but with not these specific elements that have been posed here, then a combination of this particular claim and the other claim cannot be used to defeat the novelty in this particular claim. Novelty, therefore, in patent law is a question of whether a new element has been introduced from what is existing in the prior art. This being the prior art. Confused? Let us consider in some detail what prior art is. Prior art includes all information related to the invention which is available on the date of the patent application. We have discussed that an invention is connected to a product or a process, something that serves a specific utility and can be made industrially. We have also discussed that in terms of what is copyrightable, prior information and its connection to the expression which has been made and which is being claimed as copyrightable can only have any connection if the prior information has copyright in it. If it is in public domain, then the expression can be provided in a different manner through a distinct form of expression. Let us now consider what is inventive step. Inventive step is interpreted to mean these provisions are provisions in this as well as the provisions I have cited here are from the Indian Patent Act. The provision here reads, inventive step means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes the invention not obvious to a person skilled in the art. See from this interpretation of what is inventive step, this addition of part D in this claim may satisfy the novelty consideration, but when the inventive step consideration is brought in, then we are asking a question whether to a person skilled in the art is the addition of part D to the prior art an obvious addition. If it is not an obvious addition, then it would be considered as an inventive step. Try to answer this question. How could an improvement on something known before satisfy inventive step? I'm sure you are now able to answer that if the improvement is not obvious to a person skilled in the art, then that will be considered as an inventive step. In order to explain what inventive thought is, I have sought to provide a very simplistic understanding of the very important ingredients in patent law of novelty and inventive step. I must say that this explanation has only been provided for the purpose of making a comparison between what is originality and what is novelty. But these concepts of novelty and inventive step are very detailed in themselves and need their own separate consideration. But no doubt, for our purposes, now that we look at this particular explanation, what we are able to understand is that if a person expresses an idea in a particular way, then the idea itself need not be new. And second, the expression need not be in a particular manner which is not obvious to anybody else. And therefore, we can say that in determining what is an inventive thought that is capable of patent protection is a high threshold that needs to be satisfied. In fact, about this threshold, it was clearly explained by the Indian Supreme Court in a very important case of Vishwanath Prasad Radhesham versus Hindustan Metal Industries, that not just any workshop improvement could satisfy inventive step. But isn't it possible for there to be improvements made to an existing expression in such a way that the addition that has been made is in some way transforming the nature of that expression? In terms of what you see in this image, where a person is wearing a ordinary boot, you can see in this image a boot that is specifically designed for better traction to play football on a football field. What this has done, you can see, is the addition of an inventive thought. It has been able to solve a problem. In effect, it is also functional. But a given function, for example, in this particular image, you can see there is a person who is playing football. He is playing with a particular shoe which has spikes on its soles. This particular image can be expressed in many different ways by different authors. And that is the distinction between what is patentable and what is copyrightable. Copyrights can be based on the same idea and the expression can be varied. This variance of expression is what we are interested in. Is this variance original simply because it is not copied from each other? One thing seems to be clear, that be it a subject matter under patent or a subject matter under copyright, these are both results of creative thought. What is also clear is that the satisfaction of patentability for an invention is a high threshold satisfaction, whereas the threshold for originality in comparison seems like a low threshold satisfaction. Again, what does a threshold mean here? The ordinary meaning of threshold is a level, rate, or amount at which something comes into effect. Think for a moment. The expression of a commonplace idea, should it be copyrighted? You would recall in our discussion, we had discussed the doctrine of merger, where we had stated that if an idea is expressed in such a way that the idea cannot be expressed in any other way, then the expression is nothing but the idea itself, and therefore not something copyright can protect. But an image such as this can be a common source for a variety of different expressions. An image such as this can be the source for a variety of different expressions. Should it be possible for expressions to be considered copyrightable if they are simply expressing something that is very generic? In other words, there is seemingly no effort, seemingly no skill, seemingly no application of mind. And if all that was needed was no copy, then many expressions of the same idea, albeit with similarities, would be copyrightable. Meaning what? Copyright protection would essentially act as some kind of a stumbling block, where creators themselves would not be clear on whether they are eligible for copyright protection or not. Then many expressions of the same idea, albeit with similarities, would be copyrightable. Let us consider whether effort can be a possible threshold. How much effort would a photographer have to make in taking this photograph? Sure, he would have to set the scene. He would have to ask the subjects to pose in a certain way. Is that enough effort? What about skill? Is there any skill that is then? Many expressions of the same idea, albeit with similarities, would be copyrightable. Let us consider the question of whether effort can be a possible threshold mark. What are we looking to find here? Has there been enough expenditure of labor and time in making a creative expression? Is this a threshold marker? You would see that this is inherently problematic because effort is tied to skill. For a skilled professional, it might be easier to produce a creative expression with little effort as compared to a person who is lesser skilled. Thus, should we be considering skill as a possible threshold? What about judgment or application of mind? Should this be considered as a threshold? You can see that be it effort or skill or judgment or application of mind, all of these can be used in subjective considerations on a case-to-case basis. For a painting by a given person, we might have to use this particular combination in a certain way. For a book written by a particular author, we might have to use it in some other way. Consider the case of telephone directories, something that we had touched upon in a previous session. How much effort does it take to collect information for the purpose of a telephone directory? And is the effort itself sufficient to grant to this person copyright protection? Is there any skill that is needed to collect this information? What about the manner of its arrangement? Should there be any application of mind? Therefore, we see that these considerations are very, very subjective. In fact, only if we see this on a case-to-case basis will we be able to answer what could be a possible threshold. Such is the scenario that an attempt to make some kind of an objective distinction between creative expressions and what kind of a creative expression and at what level will that be considered as copyrightable is very problematic. What we'll be looking at in the next session is whether originality has any role to play in the determination of existence of works in terms of subsistence of copyright. From there on, we will take a look at how different courts have addressed the seemingly difficult question of how originality must be considered and applied. Thank you for joining me. See you all in the next session. Thank you.